So, the Honorable Judge as in para 20, he observed that the criminal case alone was withdrawn and other promises were not honoured by the authorities. The letter of apology was further published largely, which caused disreputation to the petitioner amongst the other students. Thus, the petitioner came to understand that the promise was made in order to damage his reputation and harass him. So, you see, the learned Honorable Judge took the stand, agreed with the petitioner that here is a man, Mr. Bhupati, who is the president, filed a disciplinary criminal defamation case, and in the cross-examination, he found to be, he himself has admitted to his wrongdoings. So, therefore, the question of the petitioner making baseless allegations against the president, thereby tarnishing the profession, doesn't arise. Thereafter, here is a man who filed a case against the petitioner in all corners, civil, criminal, everything. He wanted to hound him out, and now he came for a compromise. He has realized that there is a trouble. If the same thing is prosecuted, the case is lost. So, they have used the pressure. Here is a person who is now defenseless. There is no qualification to fight the case, no resources, he is thrown out of the job, and reputation is lost. So, he is ready to accept anything, and you have misused that process and took the apology, and this caused great disreputation. Naturally, this is nothing but this. The petitioner has stated that the said apology letter, when objected, ought not to have been relied upon by the inquiry committee, but the inquiry committee ought to have gone into the merits of the allegations raised against the fourth respondent. So, here the case I found, this man has done like this, he had no evidence which he admitted. So, the merits of the case you have not gone. You are going to some other issue which you are now raising as wrong. Contrarily, there is an institutional bias and conspiracy. This is gone. So, this is a very important point. The petitioner states that he has submitted a number of documents, evidences and precedents to establish case. That is what we went through. Now, you see the para 26 is the basis for fair hearing, concept of fair hearing. Reasons are the live link for forming an opinion. In the absence of reasons, the inquiry report is undoubtedly incomplete and cannot be relied upon. Merely forming an opinion is insufficient, as the complainant is also a chartered accountant and was working as a faculty for several years. The services rendered by the petitioner with the institute also need not be undermined, and if at all the complaint is given based on some motive or otherwise, even then the genuinity of the allegations must be gone into, as the petitioner is also a responsible member of the Chartered Accountants of India. The whole, even in the comments that the judge was making, Honorable Judge, he was telling his complaint is made, is not a just junior member who started his career, he is a senior member, and a reputed person is a teacher. So, how can you just like that brush aside his allegation just without any rhyme or reason? That is what he said. Having served as a faculty for several years, the petitioner also knows the consequences, nature of allegations he is making against the institute and its authorities. Thus, the seriousness involved must be properly considered with reference to the documents and evidence made available before the Director of Discipline. Contrarily, by recording complaint and the written statement, Director of Discipline ought not to have formed an opinion that the complainant made a report without any evidence. The petitioner produced the evidence, contents in the documents with regard to the grounds raised, all must be elaborately adjudicated and the findings must be given on issue basis so as to arrive at the conclusion that inquiry was conducted elaborately and in an impartial and unbiased manner. In the absence of any such findings, the court has to form an opinion that based on improper inquiry, the complaint was closed. Though there is an allegation of bias, malafide, etc., this court is not inclined to go into these issues at this point in time, as the same would not be necessary, as this court is not inclined to adjudicate the factual merits of the allegations and the counter allegations. So, the court did not say this is incompetent. The court has got all the powers, which the Honorable Judge said repeatedly. But then he felt that it should not take over that job of which is given to the inferior tribunal. And so directions were given for them to follow them. And thus it has to be construed that the complaint filed by the petitioner was not inquired into properly and by following the established principles of law. Nature of the allegation set out in the complaint by the petitioner, the evidence submitted as well as the statement made are not elaborately adjudicated or any findings are given by the Director of Discipline in his inquiry report. Contrarily, the Director of Discipline simply formed an opinion that the complaint made an allegation against the fourth respondent without any basis, and such findings may not be sufficient as the Director of Discipline is the original authority to conduct the inquiry, which is of trial nature. Therefore, reasons and the findings in respect of each issue or allegations made are necessary to form an opinion that the inquiry was conducted in a proper manner. That is the case. Then he came to the conclusions. So, dear friends, how you will now, as a student of law or a young practitioner or even a senior person, when you take a certiorarified mandamus, once again I am repeating for you to get that point across. Here is a situation, dear friends, both sides you can analyze. You have to analyze from the angle of the chartered, the first step is from my angle, that is the petitioner. And you are supposed to understand that the petitioner is, in this case, as a party in person, is an affected party. I am an affected party, no doubts. And you are always emotional. So, over a period of appearance, I was able to get over this. And we also have problem. This is a case where I am already enjoying a stay. And the apology letter is the thread, everything basis for everybody to defend or reject. And then the way in which the comments were made, analyzed, I am off the track. I am now got into the subject. But in a writ proceedings, you have to be clear, you are challenging the order passed by the tribunal. Director Discipline, which is approved by Board of Discipline. So, Director Discipline case is the basis. So, now you have to challenge it. Challenge it as violative, and the tribunal has to follow principles of natural justice, and that is a ground. The natural justice is a part and parcel of the adjudication mechanism, and that has to be, whenever there is an allegation established, the entire case will become void ab initio. It cannot be later rectified. So, once this is gone, then nothing can be done. It has to go back. That is the concept of natural justice. So, here I have to sit on that charges made by me. Second, what is the evidence produced by me. Third, whether the opportunity is given for that person to respond. Thereafter, what did you say? And taking all this into consideration, what that fellow Director Discipline did. Now here, if you are a Director Discipline, of course, here is a biased institution. Naturally, he cannot do, because the poor person is already a B graduate and he has no knowledge. But even if he had good knowledge, he will not be able to justify. So, Board of Discipline, Toto they have made. There is a problem in the Board of Discipline also, where it was presided over by the Vice President Subodh Kumar Agarwal. So, therefore, that is also wrong. That is the point clear. Then you see how I dealt with it. So many facts judge has to appreciate. And so my trump card was, when I was arguing the matter, and the charges straight away go, this may not have cut an ice. So I try to explain the facts. These are the things done. Ultimately, I have explained, this is my charges, this is my evidence, this is the report. When evidence is there and report is like this, they have not considered it. Therefore, the case is dead and gone. Now, coming to the other side. The institute knows that is a wrong case, gone. They know that is a biased case, because institute will be in trouble. So, how do you deal with it? The institute would have answered. So, only thing is that motive. Writ petitioner's motive is the basis on which they charged. And then they asserted they followed the procedure. Following procedure is one thing, and then concluding based on the procedure is another thing. So, here evidence is submitted, not considered. So, that is a bias. Understand, procedure is one part of. Procedure is handmade for justice. That has to be followed. But at the same time, you don't follow other procedure. Why you are, what is the basis on which you came to the opinion? Generally brushing aside, that is clicked with the judge. And judge also appreciated that apology letter has nothing to do with this. Here is a man who is saying, I have done mistake to the court. Then you are saying anybody else can comment, and you have targeted another person to prove it is only to suppress the wrongdoings of the president. They have utilized that. Egoistic persons. That is the point. That is the, and the honorable judge's point of view, legality, adjudication, application of judicial mind, how he has went into the subject. See the greatness of the judge. This was the 80th, all judgments, a lot of judgments, every judgment he will pass. Within 2-3 days he passed the order. That is possible because you give mass of information, judge will not remember. Therefore, you have to assist the court by giving a written submissions. And that written submission, I have talked about myself, why I filed this case, what is my grievance, how they dealt with the grievance, and then what is the grounds on which I have come before the judge. Then after appreciating all the evidence, then the order has been passed. So far as the judge is concerned, their lordships will be interested to ensure this is not set aside. That is very, very important. Okay, right. Thank you. Over.